This is Barry Zalma on insurance. I am an attorney who is retired from the practice of law and now spend my time as an insurance claims consultant and expert witness, an author and producer of these videos. Today, I'd like to speak about and read from one of the most important insurance decisions made by the United States Supreme Court on January 14, 1884, which is still absolutely good law and still citable and relied upon by courts across the country. It is called Claflin versus Commonwealth Insurance Company of Boston, and is at 110 U.S. 81, and involves not only Commonwealth, but also Western Insurance Company of Toronto and Franklin Insurance Company of St. Louis, Missouri. The case dealt with testimony at an examination under oath as required by the terms and conditions of the policy by a person named Murphy, which had to do with the value of the goods that were the subject of a fire claim presented by the persons insured. The court dealt with the fact that after the fire that was the subject of the claim, Murphy, in making a proof of loss, stated under oath that the actual cash value of the property insured at the time of the fire amounted to $35,491.61, and that the same belonged to him, that the property insured was injured to the amount of $26,827.06, and that amount, $6,463.39, was the cost of and value of the goods totally destroyed, and $20,360.67 was the amount of the value of that part of the stock damaged but not destroyed, whereas in truth and in fact, the cash value of the goods insured at the time of the fire did not exceed $18,000. And the total amount of the loss and damage thereto by fire did not exceed $5,000, and that said goods did not belong to Murphy, as he well knew that thereafter the said Murphy was examined under oath by an agent of the insurers, and he testified falsely. The Supreme Court concluded that it was quite obvious that upon the issues as made in the pleadings and actually tried, it was material to show what title and interest Murphy had at the time of the loss in the property insured. If he had no insurable interest, that certainly would have been a defense. The object of provisions in the policy of insurance, requiring the assured to submit himself to an examination under oath, to be reduced to writing, was to enable the company to possess itself of all knowledge and all information as to other sources and means of knowledge in regard to the facts material to their rights, to enable them, the insurers, to decide upon their obligations and to protect them against false claims. And every interrogatory that was relevant and pertinent in such an examination was material in the sense that a true answer to it was of the substance of the obligation of the assured. A false answer as to any matter of fact material to the inquiry would be fraudulent if made, and if it made with intent to deceive the insurer would be a fraud. If it accomplished its result, it would be a fraud effected. If it failed, it would be a fraud attempted. And if the matter were material to the statement false, to the knowledge of the party making it, and willfully made, the intention to deceive the insurer would be necessarily implied, for the law presumes every man to intend the natural consequences of his acts. No one can be permitted to say in respect to his own statements upon a material matter that he did not expect to be believed, and if they are knowingly false and willfully made, the fact that they are material is proof of an attempted fraud, because their materiality in the eye of the law consists in their tendency to influence the conduct of the party who has an interest in them and to whom they are addressed. Fraud means an intention to deceive, where one said knowing it to be false, the law infers he did so with an intention to deceive. If a person tells a falsehood, the natural and obvious consequence of which, if acted on, is injury to another, that is, fraud in the law. An attempt is made by counsel for the plaintiffs in error to distinguish between matters that are material only as evidence and matters material to the contract and liability of the defendants thereunder, and in argument the distinction is illustrated by the following statements. Quote, where the question is as to the extent of the loss, and the insured knowingly exaggerates his loss, and makes false statements concerning the same, his conduct must of necessity be held fraudulent, for he invites the company to take a false position, to assume new and unjust obligations, to pay a loss that has not been sustained and does not exist, to do that which will prejudice and damage the company. But if the assured had made a true statement of his actual loss, and then answered falsely for personal reasons as to the parties from whom he had purchased the goods, or the value of those purchased from a certain house, then there could be no fraud, because there could be no prejudice or damage. The question would be material as evidence, but not material as to the rights and liabilities of the company. But this claim and position is untenable. The fact whether Murphy had an insurable interest in the merchandise covered by the policy was directly an issue between the parties. By the terms of the contract, he was bound to answer truly every question put to him that was relevant to the inquiry. His answer to every question pertinent to that point was material, and made so by the contract, and because it was material as evidence, so that every factual statement on the subject knowingly made was intended to deceive and was fraudulent, and it does not detract from this conclusion to suppose that the purpose of Murphy in making these false statements was not to deceive or defraud the companies, as is stated in the Bill of Exceptions and Certificate, but for the purpose of preventing an exposure of the false statement previously made to a commercial lending agency to enhance his credit. The meaning of that we, the Supreme Court, take to be simply this, that his motive for repeating the false statements to the insurance companies was to protect his own reputation for veracity, and that he would not have made them but for that cause. But what is that but that he was induced to make statements known to be false, intended to deceive the insurance companies, lest they might discover, and others through them, the falsity of his previous statements. In other words, that he attempted, by means of a fraud upon the companies, to protect his reputation and credit, in any view, there was a fraud attempted upon the insurers, and it is not lessened because the motive that induced it was something in addition to the possible injury that it might work. The supposition proceeds upon the very ground of the false statement of a material matter, knowingly and willfully made, with the intent to deceive the defendants in error, and it is no palliation of the fraud that Murphy did not mean thereby to prejudice them, but merely to promote his own personal interest in a matter not involved in the contract with them. By that contract, the companies were entitled to know from him all the circumstances of his purchase of the property insured, including the amount of the price paid and in what manner payment was made, and false statements willfully made under oath, intended to conceal the truth on those points, constituted an attempted fraud by false swearing, which is a breach of the conditions of the policy and constituted a bar to the recovery of the insurance. Such we understand to be the precise effect of the rulings of the justice presiding at the trial of the case in the court below, in refusing the request to instruct the jury as asked for by the plaintiffs in error, and in giving the instructions contained in the charge accepted to, and finding no error, the Supreme Court concluded and affirmed the judgment. Mr. Murphy collected nothing because of his fraud. This case is the prime and most effective decision about the importance of the examination under oath in any insurance claim, and in the need to answer all questions posed by an insurer to an insured truthfully and in good faith, when, as did Murphy, the insured lies at the examination under oath, where the insured swears falsely to a material question, the entire policy becomes void. And this happens every day in every claim presentation where an examination under oath is requested, and if the insured swears falsely, that insured loses all opportunity to recover. This video was adapted from my books on Zalma on Insurance Claims, a 10-volume work, and my book, The Examination Under Oath, all available as Kindle books and as paperbacks from Amazon.com. If you found this video to be useful or of interest, please forward it to your colleagues. It's free. And please subscribe to my YouTube channel, my Rumble channel, and my blog so that you can be advised of future blog posts and future videos. Thank you for your attention.